All right, hello everyone, and welcome to the third installment of the Compacts in Action webinar series hosted by the Council of State Governments National Center for Interstate Compacts. My name is Andrew Bates, and I will be your host for this afternoon's session. On behalf of CSG and our panelists, I'm glad you're joining us today to learn a little bit more about the Occupational Therapy Licensure Compact and the Audiology Speech-Language Pathology Interstate Compact. Occupational licensure compacts like the OT Compact and ASLPIC are the most powerful tool available to states to facilitate interstate practice of licensed professions without sacrificing public protection. In fact, licensure compacts actually strengthen public protection by allowing for rapid exchange of licensure and disciplinary information through an interstate data system shared by compact member states. But I will leave that to our speakers, who have prepared some great material for us today on the structure, function, and current status of their respective compacts. Before I introduce our first speaker, there are a couple quick housekeeping notes to cover. Audience members are welcome to turn their cameras on or off as they are comfortable, but we ask everyone to kindly please keep at all times unless speaking. And if you're on your phone, I believe *6 will mute you, or you can just mute yourself on your phone. This webinar is scheduled for 1 hour. We will have ample time at the end of the session for Q&A with both of our panelists. So if you have questions, please hold them until the end or drop them in the chat so that we can cover them later. And finally, this webinar is being recorded for distribution. So if you're remaining on the call, you are giving your implied consent to the recording. And now to introduce our first speaker. Megan Pudler is a state affairs manager at the American Occupational Therapy Association, or AOTA. Megan works to support, advance, and advocate for AOTA's state legislative agenda in all states, including AOTA's work on the Occupational Therapy Licensure Compact. Before joining AOTA, Megan gained experience working in state government affairs, a health nonprofit, and a state legislative monitor. Megan, I will turn it over to you. And just as a reminder, please keep yourself muted and if you're in the audience, so we don't get any background noise. Thank you. Megan?
Great, thanks Andrew, and thanks everyone for joining us today. As Andrew said, I'm Megan Pudler. I'm a State Affairs Manager at AOTA, and I'll be talking to you a little bit about the Occupational Therapy Licensure Compact. So next slide. So first, just a little bit of background as to how AOTA came to drafting and putting forward the OT Compact. Conversations have been really occurring at AOTA around licensure portability for several years, but the conversation was primarily dominated by telehealth and increasing access to services provided via telehealth. In 2000, 2013, and 2014, the annual NBCOT, so the National Board for Certification in Occupational Therapy, OT state regulatory conferences featured a number of presentations around telehealth, telepractice, licensure portability, and the current and future state of licensure portability in telehealth. In 2015, following a lot of conversations like this at AOTA and at the NBCOT State Regulatory Leadership Forum, a motion was brought forward to AOTA's Representative Assembly requesting an ad hoc committee on portability. This group was charged with the task of how to enhance licensure portability, and they looked at several different ways, including an expedited licensure process, but the group really decided that a licensure compact was the best way to move forward. The policy to pursue the compact was adopted in 2016, but there was a little bit of a pause here just because of the fact that telehealth policy really hadn't caught up yet. There was some spotty coverage across states, and we really decided to focus on payment for OT via telehealth under Medicare. During this time, several other professions did move forward with the licensure compact, including physical therapists, and as you'll hear later, the speech language pathology and audiology compact. There was really an environment here for licensure compacts, so the idea was revisited, and we really decided that we had to move forward with this and work on this. So the licensure compact was included in AOTA's strategic plan in 2018 and funded. Next slide. At this time, AOTA requested a meeting with NBCOT just because we've been really talking about this for a while with them, and we really discussed the possibility of working together on this initiative. And NBCOT agreed to work with us as well as to offer some financial support. AOTA and NBCOT signed a joint initiative announced in September 2019 And then AOTA hired the Council of State Governments, who've been working on several of these compacts to help us with our work. So next slide. So here's just a little bit about what went into developing the OT licensure compact. In October 2019, we convened the compact advisory group who met to decide what they wanted the compact to actually look like. The drafting team then began meeting in February 2020 to start writing the language to be used in states. Once we had a draft that was approved by our advisory group, we then really conducted a comprehensive stakeholder review process where we asked OTs, OTAs, state licensing boards, and our state association leadership to really weigh in on it. After that, the drafting team presented next slide. The drafting team then reconvened to review all of the stakeholder feedback as well as incorporate changes into the draft compact. Once approved by the advisory council, the language went to both the AOTA and NBCOT boards of directors, and it was approved. And after approval, it was sent back out to state associations and state regulatory boards. That all wrapped up in October 2020. And then this year in 2021, we have introduced the compact, as you'll see later, across 16 different states, and it's been enacted in 9. Next slide. So the really big picture before I really get into the details of the compact is that the OT licensure compact will allow licensed OTs as well as occupational therapy assistants to obtain a legal privilege to practice in other compact states. This joint AOTA and NBCOT initiative really creates the legal framework to make this a reality. Like most compacts, it's a multi-year initiative, requires legislation to be enacted in 10 states to activate the compact. Next slide. So what is it? The OT Licensure Compact is an interstate agreement that facilitates practice across state lines via a compact privilege. It's similar in form and function to other occupational licensure compacts that you may have heard of and ones that you'll continue to hear about in the rest of this webinar today, such as nursing, psychology, physical therapy, EMS, audiology, and speech-language pathology. It increases the demand to provide and receive occupational therapy services. And like I said, it's operational when 10 states enact the legislation to join. Next slide. The OT Compact uses a mutual recognition model, which again, like I said, is similar in form and function to other compacts. Your home state license is mutually recognized by other member states being states that have joined the compact. So essentially your home state enacting the compact allows you to join the compact. It really punches a practitioner's ticket. So for example, if the state of Texas was to join the OT compact, a practitioner with a license in Texas would then have access to apply for a compact privilege. In this example, if Oklahoma joined the compact and Texas did not, even if a practitioner held an Oklahoma license, but their main home state was Texas, they lived in Texas, they would not be able to access the compact if Texas did not also join. It must be your primary state of residence. The OT Compact allows both occupational therapists and occupational therapy assistants to practice in compact member states via this compact privilege, which is equivalent to a license. It also establishes a licensure data system for member state licensure boards to communicate and exchange information, including verification of licensure and disciplinary sanctions. Our compact is also different than others in that if an individual was to move to a new state that has enacted the compact, you can easily convert your compact privilege to a license. We do have a process to do that. Next slide. The licensure compact also offers another level of public protection. Practitioners must pass an FBI background check. There's a look back period of 2 years. So a practitioner must have an unrestricted license for the last 2 years. There's a reliance on a home state license, which means reliable tracking of practitioners. State licensing boards also get to retain control over scope of practice, over the initial licensure process. They'll have access to the centralized compact data system and be able to appoint OT compact commissioners. So each state that enacts the licensure compact will get to appoint one commissioner to the OT Compact Commission. Next slide. So it's not a requirement that OTs or OTAs in a state that has enacted the compact join the compact. OTs and OTAs can really hold their singular state license or even their state license and another state license. But if a practitioner is practicing in more than one state, the compact privilege really makes it a lot easier for them. They don't have to keep track of multiple CE and renewal cycles. There is a requirement that states that join the licensure compact have CE requirements for licensure renewal. The state of Maine recently enacted the licensure compact, and they also at the same time made some changes to their Practice Act to include CE requirements. To access the compact, a practitioner must have a social security number or an MPI, hold a license in their home state that is a member of the compact, have no encumbrance on any state license currently, and no adverse actions against the license or compact privilege in the last 2 years. They must notify the Compact Commission of their intent to seek compact privilege in the remote state. And they must also report to the commission any adverse action taken by a non-member state within 30 days after the action is taken. Next slide. So only a home state's continuing education requirements apply unless a remote state's requirement relates to scope of practice. So for example, in the occupational therapy world, sometimes an OT or an OTA may have to get additional training in different modalities. And so if that's a requirement, then a practitioner would have to fulfill that in a state. Compact privilege renews at the same time as the home state license. So again, like I said, this will really help folks not have to keep track of multiple CE renewal cycles or when their license is up. It's one at a time. You just go in and you renew it all together. Practitioners must adhere to the laws and regulations of the compact member state in which they're practicing. OTs and OTAs must meet any jurisprudence requirements for the member state where they're seeking a privilege. An active duty military personnel may designate a home state where an individual has a current license in good standing. This state will then serve as the licensee's home state for the duration of the service member's active duty. So here's just a visualization of how the OT compact will work. We borrowed this with permission from the Physical Therapy Licensure Compact. So we appreciate them for letting us borrow their visual. It's really similar to how the PT compact works. An OT or an OTA would decide they want to obtain a compact privilege. They'd go to otcompact.org to see which states have also joined the compact, any additional requirements such as those jurisprudence requirements, the fees and any waivers that they have to sign off on. They would load in any paperwork related to those things, check off which states they would like to join. Their eligibility would then be automatically verified and the compact privilege would be purchased. And so the goal is within 10 minutes, they'd be up and running with a compact privilege. Next slide. So the bottom line is that the OT compact will increase access to care. It supports military spouses. It facilitates telehealth for practitioners and patients and clients. It certifies that OTs and OTs meet acceptable standards of practice. It promotes cooperation among OT compact member states in the areas of licensure and regulation. And it also offers a higher level of consumer protection across state lines. Next slide. So this is just an overview of where the compact was introduced this year, as well as where it was enacted. As you can see, in 2021, compact legislation was introduced in 16 states. It was enacted in 9 states so far: Virginia, Ohio, Georgia, Maryland, Missouri, Maine, Colorado, North Carolina, and New Hampshire. And we still have legislation pending in the state of Wisconsin. It's passed one of the committees, it's waiting to pass another, and we'll hopefully move forward. So we're really hopeful for that 10th member state this year. In 4 states where the legislature meets for 2 years, legislation was carried over to the second year of the biennium. And then it did fail in 2 states, Texas and Utah. We're currently in the process of identifying which states will be introducing the legislation in next year. I think we have between 10 and 15 that will be pushing the legislation in. And we're really thankful for the support of everyone so far, especially CSG. And we look forward to continuing this work and these efforts. So next slide, I think it's just the Q&A and my contact information. So if you have any questions, let me know. Sorry, I talked a little quick.
No worries. Thank you, Megan, for that excellent introduction to the OT Compact. And as a reminder, we are going to hold questions until the end, but Megan will be staying on with us for Q&A. So we'll all have a chance to pick her brain at the end of the session. And now we have the pleasure of hearing from Susan Adams. Susan is the Director for State Legislative and Regulatory Affairs at ASHA, the American Speech Language Hearing Association. She serves as team lead and policy expert on state legislative and regulatory matters affecting speech language pathologists and audiologists, as well as consumers. Susan received her bachelor's degree in business administration from Towson University and her Juris Doctor from the University of Baltimore School of Law. Susan holds the Certified Association Executive credential from the American Society of Association Executives. Susan, we are glad to have you here today, and I'll let you take it from here.
Thank you, Andrew. It's good to see everybody here, and thank you for joining us. If you want to go to the next slide, please. So very similar to what you just heard from Megan about the OT Compact, the ASL-PIC is similarly structured. It's an occupational licensure compact that addresses increased demand for services. It also addresses both telehealth and in-person practice. And again, is similar to all the other compacts that are currently out there. And then you have a link to our website if you want to visit it. Next slide, please. So similar to the process, I think that the OT Compact went through, we used the Council of State Governments to work with us on this compact. And we've been using kind of their 3-step process for creating this compact and getting it up and running. We're actually in kind of phase 3 now. We met with our advisory group almost 4 years ago now. I guess it has been 4 years ago now. Our drafting team met 3 years ago. And then 2 years ago, we had a final document for use to send to the states. And that's when we started reaching out to states and getting it introduced in states, was in the 2020 legislative sessions. So since then, we have passed 15 states and are continuing to look to introduce in additional states next year, but we're also in the process now, since we have hit our threshold, our 10-state threshold, that we are creating our compact commission right now. So our compact commission will meet for the first time in January of this year, or I'm sorry, January of next year. Next slide, Andrew. So they began similar to the OT. Benefits of our compact are increases access to clients, patients, and students, facilitates that continuity of care when people are traveling, which has been especially pervasive during COVID. Lots of people traveling between states, between families, allows our military personnel and spouses to more easily maintain their profession when they're doing those change of service orders every 2 to 3 years. And then it allows, audiologists and SLPs to practice both face-to-face or through telehealth across state lines without having to go through the entire licensure process in an additional state. It certifies that our professions have met an acceptable standard of care. And it's promoting that cooperation between member states in the areas of licensure and regulation. And again, offering that higher degree of consumer protection across state lines. Next slide. So in order for states to join our compact, they have to meet the same educational requirements. So for an audiologist, that means a doctoral degree if it has been issued prior to or after January 1st, 2008. Prior to that, it was a master's degree. They also have to do a supervised clinical practicum and pass a national exam. For speech language pathologists, it's a master's degree, again, a supervised clinical practicum and a passage of an a national exam, and they have to do a clinical fellowship. These standards are 99% the same among states. There are only 2 states that do not currently have a clinical fellowship requirement for licensure. So those states are currently ineligible, but we are in talks with both Missouri and North Carolina to add that requirement back into their Practice Act so that they would be able to join the compact. Our states also have to adopt or adopt an FBI fingerprint-based background check. And then the state also must allow for the practice of telehealth for privilege holders. Next slide, please. So the compact privilege works by having an SLP or an audiologist licensed in their home state. So a state that has currently passed the compact, they would have to be licensed in that state to apply for a privilege to practice in another compact state. We say no forum shopping. So you must have a home state in the state where you currently live, where you pay your taxes, where you have your driver's license. Again, we also have that 2-year look back like the OTs do. So you have to have an active unencumbered license, and you can't have been convicted or found guilty of any felony related to the practice within 2 years. And then you have to have a valid social security number or an NPI number. And that's just so that the database will have something to work off of. The privilege to practice is the equivalent to a license issued by a remote state. We actually just got word from Medicare the other day that reiterating that a privilege to practice is the equivalent of a license for Medicare purposes, so they can be reimbursed by Medicare. And we always know that where Medicare goes, others follow. The privilege to practice renews at the same time as your home state license, and your continuing education is based on your home state license, again, unless it's related to that scope of practice issue. Active duty military personnel or their spouses can designate a home state where they have a license. And this, again, is just to make it easier for our military personnel to move between states and maintain their licensure. Next slide, please. For adverse actions, we would have a data system that would communicate and exchange information about verification of licensure and disciplinary actions. So if a home state can take adverse action against a licensee, the home state issues the license, they can take adverse action against the licensee. A remote state who issues a privilege to practice can take adverse action against the privilege to practice. The way the compact works, because your home state is your ticket to the compact, to the privilege to practice, if you lose your home state license, you lose all of your privileges to practice because you no longer meet the requirements of the compact. If a state where you have a privilege to practice decides to have an adverse action against you, they can revoke your privilege in that state. They can't revoke privileges in other states, and they can't revoke your home state license, but they will let the states know through that licensure database system that you have had an adverse action in another state. And those other states can decide if they want to revoke your privilege in that state, or if your home state wants to revoke your state license based on what happened in that privileged state. So that's where we talk about greater consumer protections. We're able to keep track of where our bad actors are. Next slide, please. So again, I mentioned our compact commission is getting ready to form. So it forms when that threshold of jurisdictions have passed the compact. Our threshold was 10. We now have 15 states that have passed the compact. It is a quasi-governmental entity, so it does have the authority to issue rules that are binding on the state. But it is an instrumentality of the member states. It is made up of member states. It is supra-state, sub-federal in nature, and it's composed of those member state officials. So it's not a private entity. It's not run by a membership organization. It is run by the members of who have adopted the compact in the states. Next slide. So it is the governing body for the compact, and it's responsible for the oversight and creation of its rules and bylaws. It consists of 2 voting delegates. You heard the OT has 1 voting delegate. We have 2 because we have 2 professions. So each state will appoint 1 audiologist and 1 speech language pathologist to serve as that state's commissioners. And they are appointed by the state regulatory board or the state licensing agency. There's going to be 5 additional delegates who could be public members, board administrators, that can be chosen by the executive committee from a pool of nominees. Each commissioner is granted 1 vote. And then we also, so that'll be, the executive committee will be 7 voting members and 3 non-voting ex officios. So those non-voting ex officios would be a member of the National Speech Language Pathology Organization, a member of the National Audiology Association, and a member of the National Council of State Boards of Examiners. Next slide, please. Commission can form committees, including that executive committee that's responsible for making those day-to-day decisions. Considering we'd have 2 commissioners from each state, it would be a little bit unwieldy to have 100 people trying to make day-to-day decisions on how the Compact Commission would operate. The commission would have the authority to hire staff, to implement those policies and procedures established by the commission. And the commissions serve agencies of the member state and are tasked with acting on their behalf, not on behalf of any particular group or organization. Again, this is not a private organization trying to run the compact. It is an instrumentality of the states. Next slide, please. I mentioned the data system. So a coordinated data system will require that the compact states submit some uniform data on all the audiologists and SLPs who apply for the compact privilege to practice. And that database will allow for expedited sharing of adverse actions. Again, that greater consumer protection piece. Next slide. So in 2020, we had 12 states introduce legislation to adopt the ASL-PIC. 6 of those states passed. Actually, 7 of those states passed, but then Georgia's governor vetoed it. And you can see in 2020, we passed in Louisiana, North Carolina, Oklahoma, Utah, West Virginia, and Wyoming. Next slide. And then in 2021, we had 16 more states introduce legislation, and we had 9 pass there. So now we have Alabama, Colorado, Georgia, Kansas, Kentucky, Maryland, New Hampshire, Nebraska, New Hampshire, and Ohio. And I should edit that because New Hampshire has been signed. Next slide. So as I mentioned, our commission is getting ready to meet for the first time. We're going to be meeting the week of January 10th, and it's going to be a virtual meeting. So again, we'll have representation from those 15 states with 1 audiologist and 1 speech language pathologist. We'll talk about seating the commissioners, about the commission bylaws and initial rules will be adopted. We'll elect the officers, review any RFPs for secretariat services. We're going to talk about the database and how that's going to operate. Additionally, next year, we're introducing a whole slate of new bills in states that have not yet passed it so that we can keep increasing those numbers in the hopes of becoming a 50-state compact. Next slide. And that's it for us. There's my contact information if you'd like to get in touch.
All right, thank you, Susan, for that fantastic introduction to the ASL-PIC. And so now we have quite a bit of time, really, for questions with Megan and Susan. So if you would like to ask a question, please use the raise hand function or drop it in the chat. And honestly, since we have a pretty manageable group size here, if you just want to jump in, turn your mic on and jump in, that's fine with me as well. But please do identify yourself and what state and organization you're with. That'd be great. Looks like we do have a hand up. Festus Simpkins, go for it.
Yes, sir. I am Festus Simpkins with the Mississippi State Department of Health. We're the licensing authority for OTs and speech language pathologists and audiologists. This year, our legislature has passed a Universal Recognition of Occupational Licenses Act effective July 1 of this year. And under that act, we have 4 programs that are affected, but 2 of them are speech pathology and audiology and occupational therapists. This requirement that we have is, it is passed, it's in law now, it recognizes people from other states that have those licenses, and they have to apply through us, of course. There's a set of regulations, and these will be finalized at October 12th meeting of the State Board of Health, and then will be filed with the Secretary of State, and will be effective 30 days thereafter. It covers most everything that you have said. That was both presentations, which I enjoyed immensely. They're very informative. My coworker, my deputy bureau director, she's been following this for some time and has been keeping me up to date, basically on what's been happening with the compact actions. But they come in, we have certain items that we have to have through the law. They apply to us. It also covers military people and things like that. So ours is getting ready. This is getting ready to go into effect, and it recognizes any state if they have a license. It recognizes them, and if they don't have any, things, adverse actions against them in that state, the Mississippi will recognize and will actually issue them a license in Mississippi. Also, even if it's, because we do have a couple of them that don't have this, that don't have a license. Not everybody licenses every profession we regulate in every state. So if a state that does not have a license, just say Utah didn't have a requirement for occupational therapists to be licensed, but they're operating as an occupational therapist. And if they meet the conditions that's set forth in law, our state would recognize their practice in Utah, and we would let them to practice in Mississippi. And it goes a little bit more in depth of that, but it has to be vetted a little bit more. But even if it's not a licensed category, if they are participating, it's almost like a grandfather clause. You're doing it before you meet the minimum requirements, we'll recognize you here. And so that's going on in Mississippi. And so I don't know how this impacts everything else. We also have a, let's see, lost my train of thought there. I'm sorry, I lost my train of thought, but that's what we're doing now in Mississippi. Oh, the other part was they also just passed a set of requirements for those that want to do telemedicine in Mississippi. And it affects all of our programs that anybody's going to be doing. And that also falls under my bureau, much to my chagrin. It even includes anybody that's in a practice. And most practitioners that we have aren't just hanging a shingle and operating independently. They're generally in a practice with other professions. That group has to register with Mississippi to do telemedicine in Mississippi from out of state. And they have to tell us every person that's going to be practicing via telemedicine or telehealth, those terms that you use interchangeably in Mississippi, to do that. And they have to tell us who's going to be doing it. They have to provide documentation that they're properly licensed in the state where they're originating from. And it also includes in-state practice of telemedicine. So it gets a little bit, in my opinion, convoluted, maybe a little bit more intricate than everybody thought it was going to be. But, you know, which is the legislature. We got it. They said, hey, you're going to do this. And so we try to do it. So that's one of the things, those are the things that are happening in Mississippi. So I really don't know how that impacts the efforts for the compact, because we have a law now that's in place. It was effective July 1 of this year. And we're just doing up the regulations so it can be operational. And also for the telemedicine, those have been in effect since April, and we're just refining the process so people could register with Mississippi to do telemedicine. Before, we had no rule or law about telemedicine. So if somebody in New Jersey said, I want to do speech pathology, audiology, or speech pathology over telemedicine or telehealth, there was no prohibition against doing it. But now there is, unless you are registered with us. And we're in the process of getting that word out to the telemedicine associations and stuff like that to spread the word of what's going on. So again, that was just informational for y'all, you know, because we've been aware of the compact efforts for some time, just like the nursing efforts that were done years and years ago. And I think there's only about 20 states in the nurses compact right now. So, but that's all I had.
All right. Thank you so much, Director Simpkins, for providing all that information and for the question. So this is something that CSG has been looking at. So I would actually take a stab at answering this and then see if Megan and Susan have anything to add. But so with the emergencies and practitioner shortages created by COVID, and with all of the new technologies that have come out in the last few years, enhancing really the efficacy of telehealth, these are really important questions for the states to be considering. And at CSG, I mean, we believe in sound policy, and we definitely believe that universal recognition, as you mentioned, where you seek to grant a license to anyone entering your state who either has been practicing or holds a certification. We think that's a sound policy, and what we believe is that compacts supplement that policy, and for a couple of reasons. One is that universal recognition can only account for practitioners who are entering your state. And so for Mississippi-based practitioners, that universal recognition doesn't necessarily allow them to, address a practitioner shortage in neighboring Alabama, perhaps. And so that's one reason that compacts kind of add to what universal recognition is doing. And as far as telehealth, I mean, it's a similar situation. I mean, a lot of states are issuing rules and laws to allow for telehealth entering the state, but similarly, compacts allow telehealth outside of the state, which opens up new market opportunities for practitioners in your state. And also, there's the public protection piece of compacts that both Megan and Susan touched on. Where the licensure data system that is shared by the states, really makes sure that a practitioner who's practicing in multiple states is being held fully accountable in all of those states, and that if a practitioner runs afoul of the board in another state, whereas without the data system, the home state and the other states in which they're practicing might not ever find out about it unless they know where to look. The data system ensures that communication is required and is rapid. And for health professions such as occupational therapy, audiology, and SLP, there is a real potential for harm by irresponsible practitioners. And so for health professions, CSG believes that compacts are, they contain these public protection fail-safes that, really can shore up public safety in interstate practice, which is a real concern for licensure boards that are going to let in a bunch of new practitioners, excuse me. And one thing I would also mention is that the Department of Defense, with whom CSG has worked on a lot of these licensure compacts due to their benefits for military spouses, believes in both of those policies. I mean, they believe in universal recognition as well as compacts, but I think DoD, and they sort of put their money where their mouth is on this, and we actually are under a cooperative agreement with DoD currently to develop additional licensure compacts for social work, massage therapy, dentistry, and a couple of other professions. And so DoD, really believes in compacts, but that doesn't mean that DoD doesn't also wish that every state would enact a universal recognition law. So I guess to answer your question quite simply, there doesn't have to be any conflict between them, and they really work together to reduce licensure barriers. Compacts just contain that kind of added bit of public protection and make it a two-way transaction rather than just one way entering the state. Let's see if Megan and Susan have anything to add there.
Well, I saw on the slide about OTs, and I guess being self-serving. One of the slides talked about the process and the jurisprudence and the fees and stuff like that. Now, are they talking about fees going to the compact, or are they talking about fees going to the state?
So it can be both. For the PT compact, which is pretty similar to both of these compacts, the fee is paid to the state, but the commission, the PT Compact Commission, also takes a fee out of that fee for the state. So some compacts charge dues to the states, and some compacts just take in a small fee on top of the state fee for the compact privilege. But in general, go ahead.
No, the main thing is that we do not receive any federal state money or federal money to run the program, so we're self-sufficient. So if there's a big negative impact on the income of the programs to the point that they can't support themselves, then there's a real problem. So and I've been doing this since 1990, and we've always been self-sufficient. Nobody's ever given us a dime from the legislature. We don't get any state appropriations in any manner, and anything that we collect goes in a special fund, and we're audited on a routine basis by the state to determine whether those fees are being spent to support the specific programs. And they're basically, of course, nothing is really ever truly protected, but they're in statute. It typically says this is for the use of this program and not anything else. And we're responsible to make sure we follow the statute and stuff like that. So that's just a little bit of a concern.
Sure, and that is something that we certainly hear reasonably often from state boards and regulatory agencies, that concern about revenue impacts. But Megan and Susan might be able to talk a little bit about what sorts of fiscal notes that we've seen in other states that have enacted these. Megan, do you want to take a stab?
Yeah, I think that's definitely a great point that you've raised. I think we've seen a handful of fiscal notes, but nothing too detrimental or big or anything. And I can put in the chat, if it's helpful for everyone, just a breakdown of what the Compact Commission fees look like from physical therapy, because like Andrew said, both are really similar. We're not quite sure what states are going to charge or what the Compact Commission will charge. But I think that's a concern. Oh, I did not send that to everyone. Sorry. There it is. So it looks like in Mississippi, for example, someone applying for a privileged practice in the state would pay $45 to the Compact Commission and $150 to the state. So it'd be $195 there. But I think we really haven't seen the fiscal notes too much. Susan, do you have more information on the fiscal notes there?
Yeah, I mean, I think out of all the states that we've been introduced in, we've only had a handful of fiscal notes, and the majority of them have been less than $5,000, I'd say. And I understand, obviously, your concerns about, being a self-funded board. You don't want to incur any additional costs. I know that I believe the Louisiana board is similarly situated, where they are self-funding, and they did pass, they have been passing compacts. So if I believe, there's not a whole lot of concern about not being able to, pay or recoup any, losses that you might have. The chart that Megan just put up shows that, states can charge a privilege fee. So instead of charging that licensing fee that you would normally charge for an out-of-state applicant, you can still charge a privilege fee. So that would help recoup any costs that you might lose otherwise.
One thing I would add as well, Director, is that Mississippi is a member of the physical therapy, nursing, and EMS compacts. And honestly, one of the best ways to learn about the impacts to revenue are just to talk to those boards that are involved in those professions, especially the PT board, since that's probably the closest example to OT and ASLP.
Well, the current director of the PT board used to work for me a lot of years ago, and when we used to license physical therapists and social workers, and they got so large. Basically, they were put under us, even though they had their own boards, and those boards were shut down. They were put under Department of Health, and then after a time, the programs grew to such a size that they petitioned to be broken off again and establish a separate board. And Stephanie was one of my licensing officials for physical therapy. She did the physical therapy part. And when they broke off, this has been way back, more than 15 years ago. They asked me, I told them, I said, she knows everything about this program. If you don't hire, you're crazy. And they hired her. So so she's the executive, the executive director of the physical therapy board. Yeah, I know Stephanie very well, and I'll be talking with her. And also EMS is within the State Department of Health. So Alicia is over that program, and Alicia Williams, and I talk to her a lot on stuff. So we'll be looking at all those things like that. And I thank you for the suggestion. That's really a good suggestion. We'll be looking at that.
And if I could just make a quick comment to your earlier point about universal licensure recognition, I think that's something that a lot of states have been taking up. Arizona, I think, was one of the first ones. And just like Andrew said, I just wanted to echo that we don't think that they can't coexist. And like he said, the licensure compact does offer that additional public protection. But furthermore, it helps the practitioners in the state, whereas universal licensure recognition just helps folks coming in. And so, like he said, it goes both ways. And just for an example, too, just using the two things that you talked about, universal licensure recognition and telehealth, with the COVID-19 pandemic, and we had a lot of practitioners that had folks go across state lines, and they actually couldn't do anything for their patients because they either didn't hold a license in that state, or they weren't even able to do telehealth over there. And a lot of emergency regulations and rules were passed to allow that to happen. But if we had a licensure compact, it would have been a lot easier for folks to be able to help their patients. it also, the great thing too about the compact is that it does really help speed up the licensure process a little bit. So with universal licensure recognition, someone would still have to apply for that license. You'd have to look through everything versus everything being in one centralized hub. So like that graphic showed, within 10 minutes is our hope that someone would be able to get a privilege to practice. So I think both can coexist really well. I think Mississippi has really been a great leader in passing some of these compacts, as well as universal licensure recognition and telehealth. And I think they can all coexist together really well. And you brought up a really good point that's often asked about. So thank you for that.
Yeah. Well, I was noticing something on the chat thing. The lady, somebody mentioned the FBI checks. Mississippi does not require FBI checks on when they get a license. If they work in a hospital or nursing home or something like that, that entity is required to do background checks on them. I've always felt that it does a disservice to the citizens of Mississippi that if I'm an OT, I can hang a shingle, because in Mississippi I don't have to have a doctor's prescription to seek my services. PTs do, unless they've changed the law, and I don't think they have yet. That's been a thorn in their side for over 30 years. So when they, if an OT just wants to hang a shingle, there's we give them a license and they've never had a background check done on them. And now the thing is, for Mississippi, when we do background checks for the hospitals that do them, or and they come through the fingerprint unit, which is in this building and an office right across away from me where I am right now. They do a FBI national check, a state fingerprint check, a state sex offender check, and we'll be doing the NCIC, a national sex offender registry check on those people. So I was just wondering, when they said the fingerprints, what does it encompass? When they said federal FBI, there's actually 4 checks that we do, not just a national check. And the national sex offender check is different from the FBI check, because that's Department of Justice that does the sex offender check. So you have to have two different programs. And of course, our Department of Public Safety runs the fingerprints through our system and also our sex offender system. So that's the 4 checks. So I just wonder how thorough what was mentioned it really is.
Thank you. I'm not entirely sure about the sex offender check, because I'm not entirely familiar with that. But the checks required under the compact are an FBI fingerprint-based check, which is, there's a particular public law that governs these, but it's an FBI record check at the federal level for federal offenses. And it's administered by the state law enforcement agency designated by the FBI. So that, I'm not sure about Mississippi, but that's usually the state police or state Department of Investigation or state judicial department, something like that. And then a state background check is also part of the background check requirement. And that's, handled at the state level. And then there was a question about whether, the background check requirement might cause the time frame for a compact privilege to be longer than 10 minutes. And the short answer to that is yes. However, it's for most compacts, including these, it's an initial compact privilege triggers a background check. And so for all renewals after that initial check, and for any other states that practitioner may be practicing in, they don't have to redo that check. And then for some states, they do check licensees at the time of initial licensure. And so if that's the case, then a licensee doesn't need to get a background check to obtain a compact privilege.
I think the thing is like for an OT, which is not picking on OTs, but just an OT that's in private practice just by themselves, and they want to go to Texas, and Texas is part of the compact, then that person has never had a fingerprint check done on her for the FBI. So I guess the other state will require them to submit fingerprint cards, however they have to do it, before they would recognize them to come in through the compact, since they had never had an FBI check done on them.
Right. If a practitioner's never had an FBI check, then to obtain a privilege to practice or a compact privilege under the compact, they would need to submit to one. Yes.
Now, let me just ask you this: Could it be? I mean, would it? If we did it, Texas would accept it, correct?
Yes.
Okay. And of course, if Texas wanted to do it themselves, they could do it, and because we don't require it.
Well, that's so under these compacts, if a state does not require a background check for licensure for these professions, they are able to implement one, and that is required to join the compact. So in the case of Mississippi, they would have to conduct background checks of initial applicants for a compact privilege, and that's something that probably can't be done by rule, but we have had some other states where they've had to implement a background check requirement prior to it enacting these compacts.
Okay. Well,
so it is something that is done.
Yeah, well, that's one of the things I've really been wanting to do for a lot of years, but politics being politics, and that's as far as I'll talk about that. But it was never allowed. We were never allowed to do it. But and the thing is, it's just the hospital. Like a person's going to go work in a hospital, the hospital runs the check. They run it through our office, but they submit the fingerprints through our office. We do the checks and then send it back to them and the results, and then the hospital or nursing home actually has the authority to review if they have a rap sheet, and rap sheet is given to the applicant. The applicant has to share the rap sheet with the hospital. The hospital review it and make a determination of whether that person is going to work for them or not. So it falls to the hospital or nursing home whether to disqualify a person or not. So if there's something that shows up, but if we will need to do something about the compact, that if they're going out of state, then we'll have to initiate some type of initial, just initial fingerprint checks for people applying for licenses. We'll have to work on that, because that may take legislation.
It sounds like that's probable that some legislation will be required on background checks, but CSG can work with you on that, as well as ASHA and AOTA, to make sure everything is in working order before you enact the compact. But yeah, just reach out to us. In fact, I'll put my email address in the chat here. And if anybody has any questions that they haven't gotten to ask, please shoot me an email. I will get emails. And I mean that sincerely. And then we did have a couple more questions from Nancy. And I mean, I know we're out of time here, so if you need to jump off for another call or something, feel free. But if we could take maybe one more question here, that'd be great. Nancy, do you want to just hop on here and you had a couple of multi-part questions here that I don't know if I can address all at once. Do you want to jump in here?
Sure. Hello, good afternoon. Thank you for talking with us. I'm from New Jersey. I don't know that we're, I don't even recall whether it's already been introduced in the New Jersey legislature or where we are, but I do know that the nursing compact is passed, the PT compact is passed. I understand there's a modified psych compact that's out there now. So I'm listening because I expect that the occupational therapy and one of my colleagues on speech language pathology would probably be interested too. New Jersey's got a couple of different things going on. Some of my questions were about the criminal history background checks, some of the concerns, because New Jersey not only has an initial criminal history background check, but also has a flagging system in place so that we learn after that initial system is done, whether there have been other offenses, convictions, or arrests that are going on, so the boards have that information. One of the questions that the latter question that I was asking, someone mentioned that the remote state could take action against the privileges if there was conduct that occurred in X state. They would report it back to the home state. The home state could take action. If the home state revokes or suspends a license, that has that ripple effect to all remote states. But what if state Z wants to take action on state X, state Y is the home state? Is that contemplated that another state can base on the remote state's action, or does it go back to the home state?
That's a great question. And the answer is quite simply, any state is able to take adverse action based on the findings of another state that's a member.
Okay.
So if a remote state revokes someone's compact privilege, then another remote state is free to do so as well as the home state is free to take action against the license in that case. But you're right that if a home state license is encumbered, then that triggers the revoking of all of the compact privileges that practitioner holds.
Yeah, I'm thinking more of the home state decides it's not as troublesome as the remote state. So the remote state did X, but the home state hasn't a problem with it. Can a third remote state decide that it too has, it doesn't have to be parallel discipline is, I suppose, another way of phrasing it. It can be whatever that particular state feels is essential for its protection of its people.
Sure. Sure. And investigative information is also included in the database. So if there's the presence of an investigation, member states are going to be alerted to that. But if the home state doesn't necessarily find that an investigation concludes, the home state decides that it's not something worth suspending the license. The compacts, and this is pretty much boilerplate language in this case, the compacts say that other states may take actions on the finding of the original member state as long as they follow their own laws in doing so. And so if the home state decides that my boss often uses the example of a marijuana offense, like not to make light of marijuana offenses by any means, but that's something that's a big deal in some states and less deal in others. So if a practitioner got into some kind of marijuana related trouble in a home state that decides that it's not that big of a deal and they're not going to revoke the license, remote states are able to take action based on that information as long as they follow their own laws and procedures in taking adverse action.
Okay, so someday I can sit down with you folks and figure out how you're going to do that when conduct that's not taken, no action in the home state, and you don't have the witnesses there, you don't have the information. But that's not everybody here needs to hear my questions.
We're happy to talk offline.
Yeah, so that'd be okay. Just New Jersey, for instance, in OT doesn't have any continuing education requirements, or are these compacts in some instances imposing substantive requirements in order for the state to participate in the compact?
In order for the state to join the licensure compact in New Jersey, for example, the state would have to bring back or have continuing education requirements. So for example, Maine just recently did that. They enacted the licensure compact and made changes to their Practice Act to include continuing education requirements. Massachusetts also just finalized their continuing education requirements. So I believe it's New Jersey, and there's one other state that does not currently have continuing education requirements for occupational therapy. So the state could theoretically enact the licensure compact, but unfortunately practitioners would not be able to join because there is no CE requirement. So that does have to be in place in order for the state to join fully.
Thank you.
I would say for our compact, it's different. So as long as you maintain your home state license, regardless of whether or not they have continuing education, you would be able to join the compact, and your citizens would be able to.
This is when I don't mean to, and everybody, I'm surprised they haven't already jumped off with some of my questions. So hanging in there is fine. New Jersey has recently passed a law that you do not need to be lawfully present in the United States. It's not a bar to licensure that you are lawfully present in the United States. I know that you folks mentioned that there needed to be an SSN or an NPI number. I know NPI numbers don't necessarily always go to an individual. Is it that the NPI number does have to be assigned to a specific individual? Because some of our folks won't have SSNs, but they are licensed or will be licensed shortly.
Yeah, I mean, I think that we would be able to figure out a way to manage that. And really, all of those numbers are for the database system to have a unique identifier for somebody in the database system.
And you guys don't think that violates the Federal Privacy Act by using an SSN as a unique identifier?
Other compacts have used the SSN also.
Doesn't make it. All right. Okay. All right. Okay. And this is, so Andrew, I'm sorry, go ahead.
Oh, well, it's also CSG's understanding that any practitioner of any of these professions that does not have a national practitioner identifier can at least get one. And the compacts accept an NPI or an SSN.
Okay. I guess the other question that I had, and I haven't thought it through to know whether it would be a problem, but if there are any substantive requirements that are imposed by this quasi-judicial body, which would be the Compact Commission, anybody facing any antitrust claims or questions or challenges following the NC Dental case a few years ago? So we can do that one offline too.
I have not heard anything about having compacts and antitrust issues.
I mean, it seems that they're opening up and not constricting competition. It's encouraging competition by allowing this sort of credentialing across state lines or across different jurisdictions. I was just curious because I spent a couple of hours today trying to deal with some, antitrust stuff. I wasn't sure how that played out.
That is a great question, but I think what Susan says is pretty accurate. I mean, it generally is looked at as opening up, market opportunities rather than limiting them. One of our counsels at CSG actually is an attorney for the Speech Pathology Board in North Carolina, and so is like really up on NC Dental. And so when we talk offline, which can be at your convenience, we would try to bring her along and she can speak to that.
Okay. Well, thank you. Again, I don't see it's not there yet. I just am always anticipating questions that might come up.
Absolutely.
Andrew, this is Lauren Lehman from Vermont, and I share Nancy's question as well. And I realize you guys will be speaking offline, but I think especially where standards in the compact are driving qualification requirements in state law, or the quasi-judicial body is issuing rules that have the effect of statute, we'd be interested in any guidance on antitrust concerns as well. So just putting that out there. Thank
you. And yeah, we're happy to address antitrust concerns. They typically haven't come up in other compacts for the reasons that we stated, but yeah, we're happy to address that with you offline, at any time. So I put my email in the chat, but I'll drop it again.
I guess one other question is are you suggesting to people to states that are participating in the compact that they advise their licensees that their licensing and application information is accessible beyond just the state where they have applied? Or is the compact not accessing any information absent a request for privileges by a particular licensee?
The latter. So at least in our case, you have to request for a privilege to practice. So nothing is shared with the Compact Commission unless a practitioner wants to be a part of the compact.
Okay, thank you. Thank you, Susan.
Mm-hmm.
Okay.
All right. Well, we've had great discussion here, and I'm really thankful for everyone who's jumped in with questions. It's been a great back and forth. That's how we like it to be. But as we are about 13 minutes past the hour, I don't want to take up too much of anyone else's time. So I just want to thank our panelists, Megan and Susan, once more for joining us. Thank you so much. And thank you everyone in the audience as well for sticking with us for this slightly longer than expected session, but we hope you found it informative. And as I said, if you would like to schedule a call with CSG and or with AOTA and ASHA to talk about the compacts, to work through some of these, meatier questions that have come up towards the end here. We're happy to do that. And I put my email address in the chat. It's abates@csg.org. Pretty simple. So yeah, just shoot me an email and we're happy to talk. But with that, I will call it a day. And I really thank everybody once again for joining us, and hope everybody has a great afternoon. Stay safe and take care.